Welcome to the last webinar presented by SPSP this year. And we're going to do something a little different than what we normally do. And we're going to incorporate discussions of the law into our discussions about safety. And certainly you'll find that there is a lot of overlap between the two. And we will hopefully convince you that the law can be helpful or harmful in your deliberations about the safety in your products and how to design, make, and sell products. But whether it's helpful or harmful, you need to know about it. And so we're going to try to get you at least interested in the topic so you can be more knowledgeable about the benefits that it might provide. My name is Ken Ross. I am on the board of SPSP, and I'm the webinar coordinator and moderator for this series. I want to thank Sedgwick Brand Protection for sponsoring this year's webinars. Sedgwick has kindly agreed to sponsor next year's programs, and we will have between 8 and 10 webinars for next year with new topics, updated topics, and we look forward to your watching them next year also. So thank you very much for participating this year. In addition to myself, I've got two great speakers, Cheryl Pacenti from Goldberg Segala Law Firm, John Cuppins from the Nelson Mullins Law Firm, and I am a product safety and regulatory lawyer. I don't do litigation, although I do serve as an expert witness in litigation, but I'm not a litigator. So Cheryl and John are a rare breed in that they are both extremely competent litigators who also do a lot of product safety and regulatory compliance counseling. And so because we're talking about the interrelationship between all of these things, I thought it'd be great to have these two who can provide the wisdom that they've received over the years in handling litigation, defending cases, and also in how that impacts the safety part of it before you sell the product, which is what we're partly going to talk about. So I look forward to their comments on this. Okay, just a couple of slides before we get into the topics. Here is my take on the goals of a safety program, at least as I identify them. Our first goal, of course, is to try to prevent incidents and accidents and otherwise minimize risk or minimize the possibility that they could occur. That is our first goal. We're all product safety professionals, and that's the best way to do this. And in order to do that, we need to think about a lot of things before we sell the product, not after, but before. Design, warnings, standards, regulations, laws, all these things we need to consider and figure out how to comply with them and do what is necessary, both from a regulatory standpoint, a legal standpoint, and a corporate standpoint, as a safety standpoint. Secondly, after sale, we have a lot of post-sale responsibilities, not just from the government, but just in general in the law, common law of product liability, to do certain things. We want to document the entire process. And if you do all these things, you will, one, do a good job for the company in documenting the history of your product, which is important just from a corporate standpoint and for future designs and future sales of products. And secondly, it'll help you create a defense. That's not our main goal in doing these things. Our main goal is to prevent accidents and just run the company in an excellent way. But these all will contribute to allowing the defense lawyers, if you do have a case, to between them and you to explain to a jury why you think your product is adequately safe, or why it didn't cause an accident, and why you're a good company that tried to do the right thing. So there's really an overlap between all of these things in any safety program. Now, many safety programs, particularly in companies that don't have litigation, they don't think about the litigation part of it. But I think you'll find that some of the laws and rules and principles in product liability will help you in product safety. So product liability cases have evolved into these kinds of allegations. And it's just the same things we're talking about when we're making and selling products: manufacturing defects, design, warnings, instructions, marketing, all the aspects of marketing the product. And that's all pre-sale. And then post-sale, did we find out what's going on with the product? Did we analyze it correctly? Did we do a good job of then taking care of the problem if it needed to be taken care of? So these are all allegations that can come up in a product liability case. Now, these are the areas of risk, but it's just consistent with what I just said about the various claims. But it goes all the way from the beginning of the development of a product, the purchase of components, the design, manufacturing, warnings, instructions, marketing, warranty. So all the things on the right side are the pre-sale activities that you'd be involved in. And on the left side are all the post-sale activities. And you can see all the things that can, responsibilities that you might have, where if you don't do a good job and an accident occurs, that could create some problems. So when we're thinking about safety, we're thinking about just not the safety just of the product itself, but all aspects of the product and all aspects of our activities as we're out there making and selling products. Now, we got to talk about litigation. Now, you all hate litigation, and maybe many of you have never had the occasion to be involved in litigation. And but litigation, whether it involves you or your competitors, others in the industry or others with similar products, can actually be helpful in the sense that it helps you identify certain things and understand how a judge or a jury or maybe the government reacts to certain things. And that can be helpful because as we design safety into our products, we are trying to predict the future. And so what do we look at? Well, we look at past problems that have occurred. So even if you haven't had problems, if your competitors have, and you can find out that information, get that information if it's publicly available, that might be helpful to you in making design decisions. Again, as the slide says, it helps identify risk, what kind of accidents are occurring, is the consumer misusing the product? It's possible that an unforeseeable misuse becomes a foreseeable misuse the more times a consumer misuses the product. The experts in a product liability case, you've got plaintiffs experts, defense experts, and they're giving opinions under oath, using depositions or reports. And these can be helpful to you in identifying either criticisms of your product or in the defense of your product by a defense expert. Sometimes the plaintiff's expert can have a very good opinion, a very well substantiated opinion that you ought to take into account when you're considering the safety of your products and the safety of your products in the field and for the future. And if you ever did go to a trial and go to a jury, you're going to test your story and see how a jury reacts to it, see how a judge reacts to it. All of these things can help you evaluate the safety of your products as they are currently designed and the safety of the products as you may design them in the future. Also, when we do go to trial, it helps clarify the law. And unfortunately, I would guess approximately 95% of all product liability cases do not go to trial. Very few cases go to trial these days. And one of the problems is that the law doesn't get clarified unless you go to trial and possibly then go up on appeal. So the law is still a little unclear, and it's different from state to state. So, we try not to go to trial unless we have to, but the cases that do go to trial might be helpful in clarifying what the law might be. And then the last thing there is a lawsuit, an expert's report, a jury verdict might impact your evaluation of whether you have a duty to report to the CPSC. Now, and how you would talk to the CPSC about what's going on in the field. Now, I'll be posting 2 articles that I've written, one on the interrelationship between product liability and regulatory compliance. And the second article, which isn't published yet, but I'm going to put in a draft of the article, discussing in more detail some of the product liability legal concepts and how they impact safety. So we'll post the slides and these articles, and maybe some other articles if there are some articles we can identify on both of these topics. So that's my introduction to the topics here. And then we picked a few topics to talk about. We don't have time to go into everything that we could get into, but we want to get you interested in the subject to do a little bit more studying and understand that the law can be helpful possibly, or maybe harmful as you evaluate the safety of your products. So with that said, let me get to my first question here, if I can get my paper out here. All right. First subject we're going to cover are laws, regulations, and standards. And obviously, your products are subject to these things. And so in considering these things, what are you required to do? And what does compliance or non-compliance, what effect does that have on a defense of a lawsuit if you do have one? And I'm going to start with John Cuppins to talk about that.
Well, thanks, Ken, and hello, everybody. I'll make a few comments and then I'll turn it over to Cheryl. One of the first things a manufacturer needs to do when it's considering designing and manufacturing a product is, and it may seem obvious, but you need to identify which authorities apply to the product. And you need to do this early on. This should be in the early stages of product development and risk assessment. And the reason for that is because you want the information you learn, and you want your compliance with these authorities to be kind of incorporated into or baked into your product design, your instructions, your warnings, etc. So not only is compliance essential to the viability of the product, but these authorities will help you think about safety issues in a way that I think you'll find helpful. And you may need some help, making sure that you identify all applicable authorities, because there could be several. So what are the types of authorities we're talking about? First, in the United States, there are federal, state, and sometimes local legislative bodies that enact laws. And then also government agencies that issue regulations. And these laws and regulations outline the criteria a product must meet. And if the product does not comply with these laws and regulations, then the manufacturer can be found liable in the lawsuit. If the plaintiff can show that the non-compliance was the cause of the injury in that particular circumstance. So bottom line, you must comply with laws and regulations. Second, there's a category of safety standards called mandatory safety standards, and those just mean safety standards that are issued by a government. And as the name suggests, you have to comply with these, or you risk being held liable for non-compliance. So they kind of fall from this perspective in the same category as laws and regulations. And then third, there are voluntary standards. So instead of being issued by a government, voluntary standards are issued by organizations like UL, ANSI, ASTM, and others. And Cheryl is going to talk more about these types of standards in a moment, but I'll just say that most of the time it is advised to comply with these types of standards. And if you don't, then you better have a credible explanation for why it was not reasonable for you to do so in your circumstance. So you should comply with applicable standards, and compliance helps you avoid liability. And it helps you demonstrate that you acted reasonably in the design of your product. It strengthens your ability then to later defend a lawsuit when you can show that you complied. However, I want to be clear about one thing. The fact that you complied with an applicable standard does not get a lawsuit dismissed in and of itself. It's not a get out of jail free card. That's because the legal standard in a lawsuit is that you must show, or it must be shown, that you didn't design a product that's reasonably safe. So you need to show that your product was not defective, or that it was reasonably safe, is the other side of that coin. And so this is a concept that is broader than compliance with standards. Again, a compliance is a positive for sure, and you could very well be sunk if you don't comply. But you can't just check the box that you complied with the standards and consider yourself insulated from liability. Indeed, you can expect that the plaintiffs will argue that the standard is the bare minimum and that more should have been done to make the product safe. What the law requires is that a manufacturer act reasonably to design a product that's not defective, to design a product that's reasonably safe. So there's an element of judgment that is just included in that can't be eliminated. And so what does that mean? That means a manufacturer should consider whether compliance with standards alone is enough to make a product reasonably safe and free from defects, or whether additional steps need to be taken to achieve that goal. Often it may make sense to do more, but the touchstone is always going to be, will you be able to demonstrate that what you did was reasonable under the circumstances? Now, I'm going to mention one other issue and then turn it over to Cheryl. Sometimes you may sell a product in different countries, and the different countries may have different safety laws and standards. And you'll have to decide whether you sell the same product with different safety features in different countries. Just be aware that if you do that, these differences will be used against you in a lawsuit in the country where you sold the product with fewer safety features. We all know the United States is among the most litigious countries in the world. And if you sell a product here in the United States and it doesn't have, for example, all the safety features that it's required to have in Europe, you can certainly expect that the plaintiff's lawyer will argue that you only made it safe where you were forced to do so. So that's something that you need to give some thought to. With that, I'll turn it over to Cheryl. Thanks.
Oh, thanks, John. Up on the screen, we have the two different phrases or terms, mandatory laws and voluntary standards. But I think all of us would recognize that voluntary standards are not truly voluntary, that word is really a misnomer. I've spoken to manufacturers outside the country in various parts of Asia, and they seem to be surprised to hear that we have what we call voluntary standards that really aren't. As John mentioned, there are various organizations, ASTM, ANSI, UL, that publish what are considered to be voluntary standards. But in the US, voluntary standards are usually developed as a consensus, as a collaboration between manufacturers, sometimes government agencies contribute, consumer groups, and those standards are issued with respect to a very specific slice of an industry where the government really doesn't have a lot of resources to develop standards. With respect to consumer products, the CPSC is required, before they issue regulations and mandatory standards, they're required to consider whether there are voluntary standards that are applicable to that product or a component. So when we talk about voluntary standards, they are one step away from being mandatory, because at any point in time, the CPSC could come in and make them mandatory. Further, as a practical matter, if you're selling a product through normal retail channels in the US, most retailers will insist that a product that's subject to a voluntary standard meet that voluntary standard and be tested to that voluntary standard before they'll allow it to be sold through their channels. So voluntary standards are really anything but. When it comes to product liability, if you have violated a mandatory standard, that's very damning evidence against you in a product liability lawsuit. But if you have violated a voluntary standard, that's going to be equally damning. So we shouldn't consider there to be a large chasm between what's a voluntary standard and what's a mandatory standard when it comes to consumer products. I'd also like to mention that, as John alluded to, a mandatory standard is the minimum. You can't sell a product a consumer product in the US if it doesn't meet a mandatory standard. The Consumer Product Safety Commission has regulations that permit the CPSC to seek civil penalties against a company that sells a product that does not meet a mandatory standard. That's considered a prohibited act, and a company could be subject to civil penalties of up to $18 million, I believe the latest maximum is. So the companies do not frequently violate mandatory standards because not only can they be subject to liability and lawsuits, they could be subject to civil penalties by the CPSC. The mandatory standards allow you to sell a product in the US, but companies have to be careful that their products not only meet the mandatory standard, but that they don't fail when they are tested to levels above a mandatory standard. If a mandatory standard is a performance standard, for example, and it requires that a component part will be able to withstand a certain weight, you don't want to sell a product that breaks at 110% of the requirements. You don't want something that just meets the mandatory standard, but can fail after that, after testing under those circumstances. So a lot of companies, when they are faced with a product liability lawsuit, will be very concerned, and they'll tell us, well, the product is tested to very regular standards. We have test reports. It passes all of them. This is what the industry requires. And unfortunately, that's usually not going to be enough. Ken?
Okay, thank you. One thing I'll point out, and I think we'll probably deal with it next year in a webinar, is that sometimes during the standards making process, companies are either fighting with each other, or the CPSC participates in the standards development and they disagree with what the industry is doing. The CPSC, I guess, recently rejected an ASTM standard, I think, if I've got that correct. But just to understand that plaintiffs' lawyers will ask for the minutes of the standards committee, and that's not privileged, it's not confidential information. And so if there is in the minutes, disagreements and discussion about how safe, it should be required during the standards process, and disagreements over the finished product, that's gonna, could muddy the waters on the issue of whether that standard was really adequate or not, or whether you should have made your product safer than required by the standard. So sometimes these standards development processes can get kind of muddy and messy, and plaintiffs' lawyers are going to look for any reason to argue that your product should have been made more safely. And that could be one way to do it. Okay, second question. Sometimes people are hurt because they have not used the product as intended. What do you have to do? What does the manufacturer have to do to try to prevent people from misusing the products or using them in an unintended way? And with what you do, can that be a defense in a product liability case? I'll call on John again.
Thanks, Ken. This concept of misuse is one that at the same time is some basic common sense, but also has some elements to it that are kind of confounding. But a user's misuse of a product is a defense to a product liability lawsuit. And let's just talk for a minute about what that means. A common definition is a use that's so unusual that the average consumer could not reasonably expect the product to be designed and manufactured to withstand it, and which the seller therefore need not anticipate and provide for. So the basic idea of the misuse doctrine is that products are designed for specific tasks in specific environments, and no product can be made safe for every purpose or use. Consumers have their own responsibilities under law. They have to use a product properly. They're supposed to follow the manufacturer's warnings and instructions. And if the consumer doesn't do that, then he can't reasonably demand that the manufacturer be held responsible for his misuse. I'll just say that the same logic applies to abuse of the product or alteration of the product, same concept. But I want to now just kind of dispel a myth. It's not true. And, you know, a common theme here is that there are no kind of bright line, black and white tests for a lot of these things. There's always a reasonableness component or a judgment component. And that's true here. So it's not always true that a manufacturer is never liable if the product is misused. It depends. The defense only applies to what's called unforeseeable misuse. I think maybe an easier way to look at that is that a manufacturer is only responsible for injuries that come from uses that are reasonably foreseeable. So if it is something that the manufacturer should have reasonably foreseen, then it can still be held responsible. So then that brings us to this concept of reasonable foreseeability. Scholars and courts have readily acknowledged that the reasonable foreseeability is a vague concept. And that may seem frustrating. Again, there's not a black and white test of what's foreseeable and what's not. And further confounding is you'll look at court decisions from across the country and you might see that they've come to different conclusions about whether a misuse is foreseeable, depending on the particular facts involved. An extreme example might be, and I've tried to think about examples and it's not easy, but an extreme example might be that you could not reasonably foresee, if you're a manufacturer of a surge protector, you know, that you would plug a bunch of things into, you couldn't reasonably perceive that someone would stretch that across the water so that you can watch TV while you're sitting in your swimming pool. Okay, that's an extreme example of, you know, that's beyond a commonly accepted use. But on the other hand, concepts like loss of concentration or loss of control when using a product are more likely to be in the realm of foreseeable misuse, and therefore they should be accounted for in your design and warnings and instructions. But one thing I just want to say is that, you know, as we talk about, you know, how difficult it might be to put a bead on some of this, keep in mind that this is a legal concept that's intended to protect the manufacturer, in that it's not liable for uses that it could not reasonably foresee. So what does that mean? That means that the manufacturer has to do certain things to kind of account for the foreseeable misuse. During the design process, the manufacturer needs to consider, what are the misuses of this product? Are these foreseeable? It has to analyze product uses, analyze risks associated with the use of the product and possible failure modes, and then it needs to act reasonably. It needs to apply good engineering and good judgment to identify which misuses seem to be reasonably foreseeable. Once the foreseeable misuses are identified, then the manufacturer must design its product in a way that avoids that risk. And we're going to talk more about this in a future question. The last thing I'll say before I turn it over to Cheryl is, be aware that once a manufacturer starts selling a product, it might gain additional information, because now it's going to hear from its consumer, from its customers, about how they're using the product and what's happening to them. And so, you know, they may, through that process, learn of additional misuses of the product, and they need to keep an eye on this. So additional foreseeable misuses that are identified could prompt the manufacturer to make changes in the design, or to change its instructions or warnings, or to take some corrective action. And so those are all things that need to be considered. I'll turn it over to Cheryl.
Yeah, I'd just like to add that some companies take the offensive when it comes to trying to establish what reasonable use and reasonable misuse is. A lot of people, a lot of companies will put the product in a consumer's home and have a consumer use it and respond back with what they like, what they didn't like, how often they used it, when they used it. And companies that do that can gather information that might be helpful to them in the future to show that a particular pattern of misuse didn't show itself during pre-market testing. And that can be something that's helpful to maybe ferret out potential misuse that hadn't been discovered, but those records could also be used offensively to show that the company did a good job trying to figure out how the product could have been misused. And this particular misuse was shown either rarely or not at all. And post-market, the same type of information can't be created, but it certainly can be gathered. Many companies want to set up a system for document management and potentially getting rid of information from consumers that don't seem to have any business purpose. But conversely, many companies can use consumer feedback and consumer data offensively to show that in X number of years after selling X millions of products, they had never or had very, very rarely heard from consumers regarding a particular kind of misuse. So companies can think of ways to use the information that they have or develop information prior to sale to show that they considered how a product could be used and misused, and that information indicating whatever crazy thing the plaintiff decided to do or the injured party decided to do was not something that was common. Ken?
Okay, thank you. And let me, I think I may post another article on foreseeability because this is such a murky topic and an important one. The example is that John didn't have, and the one that I've had personal experience with, was a fellow who used to juggle my company's chainsaws for entertainment. And was that, because I had a videotape of him juggling our chainsaws, did that become a reasonably foreseeable misuse? Well, no, because the courts have said that everything is foreseeable, but that doesn't make it reasonably foreseeable. And unfortunately, when we use the word reasonable, what it means is that the jury gets to decide what's a reasonably foreseeable misuse as they decide the case. So you as a manufacturer need to figure it out as you're designing products or considering products in use. After we learned about the chainsaw juggler, it turned out that chainsaw juggling became a topic in a Calvin and Hobbes cartoon later on. And I began to wonder, gee, maybe this is reasonably foreseeable misuse I have to worry about. So it's a moving target, as John said. You consider how people are using the products. Now, we have had a question, which I'll deal with later. Hopefully, we'll have time to do it, on how do you consider what's reasonably foreseeable as you're doing risk assessment, which we'll talk about later on if we have a chance. Anyway, next question. If people don't follow product warnings and get hurt, what can you do about it as a manufacturer? And how do you defend yourself in a product liability case? And it really ties right back into reasonable foreseeability. Is it reasonably foreseeable people will not follow warnings and instructions? Well, everybody says, of course. So to the extent that you've designed your product as safely as you can design it, and really can't do any better, and lots of warnings and instructions really go to future maintenance of the product and maintaining that product in a safe condition. So it really has nothing to do with the original sale of the product. So what are you supposed to do when it's reasonably foreseeable people are going to not follow your warnings and instructions? And how do you defend yourself? John, we'll start with you again.
Thanks, Ken. And so if people don't follow warnings, is that a defense? Maybe. It depends on whether a warning is the best way to address that risk. And then if it is, it depends on whether the warning is adequate. So a manufacturer designing a product always has to determine how safe is safe enough. One way to assess this is to assess whether there's an alternative, a feasible alternative design that's safer. And so consideration of that should be part of your product development process. And this is almost always an issue in product liability lawsuits because the plaintiff in many states must show there was a feasible alternative design, but even if they don't have to, they will often show that there was a better design out there and you knew about it and you didn't use it. So how does a manufacturer make a design decision about these issues? It does a risk assessment that identifies and ranks the risks and decides how these risks can be eliminated or reduced. And in that vein, there's a concept known as the safety hierarchy. And the idea here is that a manufacturer should, number one, first try to eliminate the hazard through design changes. And if it can't do that, then the next thing it should do is add a guard to protect against the hazard. And then finally, if those options are not feasible, then it should warn about the risk and perhaps provide instructions about issues like training and PPE. So the reasoning behind the safety hierarchy is that guards can be removed, warnings can be ignored, and so the best way to avoid a hazard is through changes to your design. These decisions based on a risk assessment are really important to product safety and to enhance your ability to defend product design in a lawsuit. And the safety hierarchies can certainly be a useful tool. It's something you need to be aware of, it's something you need to consider. But, once again, it's not a black and white. It's not, just one or the other. It's a situation where judgment and reasonableness need to be considered. So oftentimes it may make sense to have some combination of those three options to be the best way to make your product safe and to enhance your ability to defend your decision. So again, judgment is required. Now, most products do have warnings, and what the law requires is that warnings must be adequate. What does that mean? Substantively, it means that a warning must clearly do at least three things: identify the risk, tell the user how to avoid the risk, and inform the user of the consequences of failure to avoid the risk. So an example I thought of is, a product that I don't have a lot of use for, but most people have in their homes is a blow dryer. And the blow dryer is something that if you, were to, you're using it in the bathroom and if you're around a tub full of water or whatever, it could provide a risk of electrocution. And so a good warning on a blow dryer is going to say risk of electrocution, don't put in the water, how to avoid the risk, don't use it around, these circumstances, and let them know that if they don't do it, it's a risk of shock, electrocution, serious injury, or death. And so substantively, the warning needs to achieve those things to be adequate. Then procedurally, what I mean there is, even though it's got that content, the warning must be conspicuous and it must be understandable. So that involves considerations like which warnings should be most prominent and how to avoid giving so many warnings that the important ones are drowned out. Those are all reasonable things to think about. And we talked about standards, voluntary standards, ANSI standards. There are standards, ANSI standards, and maybe ISO standards that address how to communicate warnings and instructions. And they discuss things like which word to use, when do you use danger, when do you use warning, when do you use caution, and for warnings that are in color, which colors kind of correspond to those what they call signal words. And they have other useful guidance about the best way to present your warnings to communicate them well and make them understandable. So we talked about voluntary standards earlier, but this is another voluntary standard, and I always recommend that manufacturers refer to these ANSI standards regarding communication of warnings and instructions, and be aware that compliance with these standards likely will help you defend the adequacy of your warnings. Now I'll turn it over to Cheryl to discuss some special considerations related to warnings.
Yeah, thanks, John. Unfortunately, many products have very adequate and very clear warnings in their instructions, perhaps on the packaging, but because the products don't live with their instructions and packaging, or are passed down or sold in the secondhand market or sold at yard sales, a lot of that might be lost, and people can get hurt and turn to the manufacturer in a lawsuit when they do. Part of being conspicuous is having the warning available to the actual user of the product, which is an issue. Some of the things that some of my clients have done prophylactically is to have studies performed to test their warnings and the conspicuousness of the warnings on the product. You can't have every warning on a product itself, but there are human factors organizations, for example, who can conduct a study to show that people, randomly selected people who are looking at the warnings were able to see them, or they weren't able to see them, and then something could be corrected. And they have used this type of testing to show in lawsuits that they took care to make sure that a reasonable user of the product will be able to see and understand how to properly use the product and what to avoid when using the product. So that's one tool that can be used to make sure that as the product's being used, you have evidence that the reasonable person could see and understand it. My experience in lawsuits is that if a warning is a good one and it's an adequate one, oftentimes the plaintiff is going to say he didn't see it and he didn't read the instructions and he didn't read the warning. But having a warning, especially a very important one on the product, and having independent testing that shows that it is both conspicuous and understandable is very helpful under those circumstances. One concept that many manufacturers use is task interference, where, for example, if you're using a heating pad, the cover of the heating pad has the warnings right on it. You have to see it when you're using the product. I've had manufacturers, when they are dealing with a product where misassembly could cause a safety issue, add either a tape over an important part of the product or something that physically has to be removed in order to assemble and use the product, so that it would be difficult for the original assembler to say, I didn't read that booklet, I just intuitively put the product together. So those are types of tools that can be used to ensure that the cowboy who throws away the instructions with the packaging and goes to town to use what seems to be a simple product will at least be advised as something that might be unusual, but very important. Another consideration is that warnings won't necessarily help in certain kinds of actions. Small children can't read warnings, and in many jurisdictions where there's a product liability action and a child is hurt, either on a children's product or on a product that's not intended for children, the parent's failure to read the warnings or to follow the warnings is not going to be attributable to the child. So if we have a negligent parent who lets a child get too close to something that might be dangerous, for example, all the warnings in the world is not going to be a perfect defense. The issue will come down to, in most states, strict product liability law, where the jury is going to be asked whether the product is reasonably safe or not reasonably safe. So that's something to consider when there are products that could injure children who might not be able to perceive the danger. The warnings alone won't be enough. In those cases, many manufacturers have amplified those types of warnings to ensure that they're conspicuous to parents who might end up having children too close to them. And just one more point I'd like to make is that I know that sometimes warnings often look silly, And there are all types of websites and memes that show silly warnings that that warn against behavior that almost nobody would take, such as, don't iron your clothes with clothes on and things like that. But all of those types of things, they may seem silly, but warnings are meant to protect a company. If you don't have a warning and you should have had a warning on a product, the case is virtually indefensible. So having the silly warnings is better to protect the company than not having the warnings when you're defending a liability suit.
Okay, yeah, and then there's an issue which we can't talk about today, and that is overwarning. And to Cheryl's point, and is there a risk to overwarning, which I've also written about too. But we're going to do next year, we'll do an individual, a separate session on warnings and a separate session on instructions. And we'll bring in the human factors folks who are dealing with that and dealing with the standards to give us an update on those two issues. So we'll try to expand on that a little bit later. We got one more topic, and it's possible we'll go a few minutes over, if that's okay with you. And I apologize if we don't get to your question, but what I will promise, those of you who submitted questions beforehand, if we don't get to your question here, we will individually respond to your question. So, because we know who you are, because you submitted beforehand. So you'll get an answer to your question. And then secondly, we have several questions that came in during the session. If we don't get to those, we'll get answers to all the questions and we'll post them on the website also, because I want everybody to get their questions answered, but I'm respectful of your time. So, but the last topic I want to discuss is really important. We call it in the law post-sale duty to warn. And it's really encompasses all of your post-sale responsibilities, either under the common law or under regulatory law. And this is the nastiest, largest, longest acting allegation you could ever have. Product liability claims generally refer mostly to, was your product safe when you sold it? Post-sale duty to warn concepts are, was it, even if it was safe when it was sold, did it after sale become unsafe, and should you have done something about it? So the length of the risk in post-sale duties lasts forever, as long as your product is out there being used. And you could have accidents 20 years after the sale of the product, and still there'd be a claim that the manufacturer should have recalled the product or done something about fixing it in the field if you become aware of these accidents afterwards. So all of your conduct, all of the information you receive after sale is relevant information to trigger a so-called post-sale duty to warn. Now there's not a post-sale duty to recall the product under the common law. But of course, if you report to the CPSC and you recall the product, then you've done that. So it's both common law, which is court-made law, and or legislative made law. And then there's also the regulatory law that has to be considered. So this is a big, nasty cause of action claim that can be made in a product liability case. And having spent a lot of my time over 40 years dealing with this, it is really hard to defend these kinds of cases, because you're having accidents. And of course, an accident in the lawsuit, then the claim is that you could have done more, and that would have prevented the accident to my client. And sometimes it's kind of hard to defend that, even if you did a great job. So with that said, I wanted to turn it over to John to tackle that situation, and then Cheryl. And again, if we don't have time for the questions, I apologize, but we will get you all the answers to these questions. And there's some good questions in here, but I wanted to be sure to lay out this topic, particularly from a litigator's standpoint of how hard is it to defend these cases, and how far do you have to go to take care of this problem? So John.
Thank you, Ken. Yeah, and this is a good example of another reason that companies need to monitor information in the field, and be willing to react to new information. But let's just assume that based on new post-sale information about your product, you performed a recall in coordination with the CPSC. First thing is, just because the CPSC approved your recall, that does not mean that you can't be liable in a product liability lawsuit. If your product injured someone, you can still be sued and you can still be held liable. But keep in mind that for a recall to be relevant to the lawsuit, the recall must be about the same defect that's being alleged in the lawsuit. Second, in a product liability lawsuit context, as Ken said, most states do not have a cause of action, a legal claim that can be brought for failure to recall. That's the domain of the CPSC. But most states' laws do say that if you do decide to do a recall, then you have to do it reasonably. And so that gets into concepts of, is the remedy reasonable? Is the scope of affected product that you determined reasonable? Are the steps that you took to notify consumers reasonable? Those kinds of things. But anyway, how do you deal with all that in a product liability lawsuit? In that setting, product liability lawsuit setting, what you're going to be judged by, what the legal standard is, first, was initially your design reasonable, at the time that you designed and manufactured the product? And then secondly, did you act reasonably when you learned of this new post-sale information? And I emphasize new. If it was information that you knew way back when, then that could be a problem for you. But if it's new information and it fairly is, something that you didn't know about before, then it's how did you react to it at the time? So most of the time, the best approach is to embrace it instead of trying to run away from it. And by that, I mean explaining to the jury that the decisions you made during the product development process were based on a thorough and reasonable analysis. But as a good company should, when you learned of new information that required additional action, you took it. You didn't try to sweep it under the rug. You acted in good faith every step of the way. Your actions were reasonable. So, but again, this is a good example of, people wonder, what kinds of information should I try to preserve? What kinds of information should I try to document? And so to me, this is a good example of why it's advisable to give some thought about how to memorialize things like design considerations, so that should you need to down the road, you can present evidence of your reasonable conduct at trial. Cheryl?
Yeah, I would just say that embedded in this question is, if a company is considering making a product change that might make the product safer, is that going to be a risky proposition? And what should the company be considering if they make a change that doesn't require a recall, but a change that makes the product safer? And under all circumstances, I would urge all companies to take that leap, to never decide, well, if we make this change, then it'll make the older product look like an unsafe product, and make it look like we realized that there was a defect. Certainly, if there's a defect with the original product, those facts are those facts, and potentially a CPSC must get involved. You might have to recall. But if it's not a circumstance that requires a recall, making the product safer will always be better for the company in litigation, simply because there are safer versions of a product. Their product safety has been advancing for decades and decades. Safer versions of products do not damn the earlier versions of the product. Instead, it makes the company look substantially more responsible. I would agree with John that a product recall doesn't guarantee that there will be no lawsuits. And in fact, there are lawyers out there, class action lawyers, who make cottage industry of picking apart any recall that occurs and just trying to make money, especially if the number of products that were recalled is large. And this is a topic for a completely different seminar. on how to conduct a recall to minimize the chances that you are going to face substantial liability in a class action lawsuit after that.
Okay, and let me just say, because I've served as an expert witness in recall adequacy and litigation for over 20 years, and you can always do more. And the plaintiff will always have somebody to testify you can do more, and it's kind of hard to say, no, you couldn't. So where is that reasonable conduct, and where do you stop? When I was the head of product liability at Emerson Electric, we did a recall that involved 600,000 products. And we sent out 8 million letters to every consumer in America we could find. And then I had to defend the adequacy of the recall. And interestingly, a lot of juries actually reacted positively to our attempts to do it. They thought we were reasonable. But of course, you get a small percentage of products back, and you're recalling a product. And by definition, you're almost admitting there's a defect in it. So what's reasonable? How do you do that? And what kind of a defense do you provide? These are critical issues that need to be considered. One, when undertaking a recall in the first place, as John said, that if you voluntarily undertake a recall, you have to be reasonable with it. Now, that doesn't mean you have a legal responsibility, at least under the common law, to do a recall. So these are very important issues, and I certainly recommend when you consider any of the post-sale duties, you involve litigators who can at least help you guess on how a jury would react to your conduct and the reasonableness of your conduct, even though you don't have a case yet. Possibly you don't have a case, but you may have to defend one. But so, how can we do this so that we can present the best story to the jury in the event there is a lawsuit? Well, we do have a few moments here, so I want to we'll deal with a couple of questions here. Let me put that up on the screen. Cheryl, why don't you deal with the first one, and you can kind of state the question in your answer. I think it's on self-repair.
Oh, right. A question came in as to how to best fortify a company with respect to some of the newly passed self-repair or right to repair laws. These are relatively new in that I don't think there have been any consumer product right to repair laws passed yet. New York is slated to be one of the first states to have a right to repair electronics, meaning that consumers and non-authorized repair shops will have the right to repair electronics if this law is signed by the governor of New York State. And it is, in the automotive industry, right to repair has been a standard for the past several years, where it used to be that only authorized repair shops could do certain repairs. And after a memorandum of understanding was entered into, auto manufacturers have agreed to allow the information, instructions, and tools and parts that used to only go to authorized repair shops to go to independent repair shops and to consumers. The same movement is being undertaken throughout the country regarding consumer electronics. The question was whether these how to prevent or deal with the potential for product liability lawsuits with respect to these new laws. I suppose it would depend on the product, but to the extent that the instructions that are given to authorized repair shops clearly, adequately, and completely take into consideration the safety implications of the repair. In other words, what could happen if a repair isn't done properly to the product itself, or what could happen if the repair is not performed safely and something happens later, to make sure that those instructions uniformly across the board are adequate. Presumably, authorized repair shops have received instructions like this, and the instructions have been vetted, but I would have a careful review be made of the things that have been given to the authorized repair shops that now have to be given to ordinary consumers. And the other point that I would make is that consideration should be given to being able to identify a repaired product versus an original product. And that's something that's a technical issue that only the manufacturer would probably know the best way to go about doing that. But it would be important. Many people who perform their own repairs on all kinds of consumer products don't own up to it. And it behooves the manufacturer to be able to establish that the product that they produced was safe, and that some kind of subsequent modification made by a consumer or a repair shop that might not know what they're doing was the cause, and to be able to identify the repaired products versus the not repaired products. I don't know, Ken, John, if you have any other comments on that issue.
No, if you don't mind, let me just deal with the last question real briefly. I'll paraphrase the question. Basically, the question is, when you're doing a risk assessment, do you put into your assessment something that may be an unforeseeable misuse, basically? Because you can foresee anybody, I can foresee people juggling chainsaws while they're running. Do I put that into my risk assessment? Well, I think as a lawyer, I'm not an engineer, that putting clearly unforeseeable misuses, or not unforeseeable, ridiculous misuses that are obvious hazards, putting those into your risk assessment, is that an admission that it is a foreseeable misuse? And I think there can be an argument made for that. So I guess my conclusion would be, if you put every misuse you can think of in your risk assessment, you want to at least label those that you believe are not foreseeable, and don't sit there and try to evaluate the probability of somebody juggling a chainsaw while it's running. I mean, that's ridiculous. So you can put it in there and say, yeah, we thought of every misuse we could think of, but these 5 right here, we did determine are not foreseeable, and it's an extremely remote risk or unknown risk at all. And therefore, we're not going to do the normal risk assessment process for those. The other way to deal with it is that those misuses that you would argue are unforeseeable, I wouldn't include them in the risk assessment at all, because you just can get into trouble to argue about why you consider them unforeseeable or not, and why give the plaintiff's attorney or expert the idea that you even thought about this misuse. So I think I would vote for the second one and not the first one. But it's a little bit tricky, because it's in the eye of the beholder. Your unforeseeable misuse is somebody else's foreseeable misuse. John or Cheryl, do you have any comment as a litigator on that? Which one do you think is the best way to deal with it?
I think putting in ridiculous misuses would either lead to watering down the warnings, and nobody wants to do that, or suggesting that the actual potentially ridiculous misuse that the plaintiff may have undertaken before he got hurt was something that should have been thought of. If you're going to put down juggling chainsaws as a potential misuse, then a plaintiff that uses a chainsaw to, I don't know, cut up a cinder block or do something that might have been a little less crazy than juggling a chainsaw, but a little less probable than juggling a chainsaw, I think you get into bigger trouble by including the more ridiculous.
Okay.
Yeah, I agree.
Good. Thank you, John, for that succinctness. Okay.
Well, I know we're running out of time.
Yeah, our next webinar will be January 18. We're going to have 2 CPSC practitioners talk about updates on CPSC activities for next year. You can contact us about any further questions you have. We will try to take any of the remaining questions and respond to those and to put them up on the website. There are only a few more that we didn't quite get to, and I apologize for that. And the video of this webinar will be on there if you have other folks at your company who you think would like to see it. And we appreciate your attending today and sticking through the entire hour and 5 minutes more. I apologize, we went over a little bit. Again, thanks to Sedgwick for sponsoring the program. We appreciate your support, and we appreciate all of you for participating in this the last webinar of 2022. Thank you all very much, and we'll stop the program at this point. Thank you again.
Thank you.